Good afternoon. Welcome to today's webinar brought to you by MyHR Australia. Today's subject is really looking at some recent changes to workplace laws in Australia and really looking at the extent of those changes and how they will have impacts on particularly small and medium-sized businesses. So we'll sort of do a sort of overview in terms of what the changes are, and then really looking at sort of broader implications and how businesses can respond to these changes and prepare for them coming into effect. So before we jump into everything, I should probably introduce myself. My name is Julian Hackenberg. I'm the head of HR advisory in MyHR Australia. And today I'm joined by my colleague, Robert Minkus. Robert, tell us about yourself.
Yeah, well, thanks, Julian. It's good to get in front of the MyHR client base. But basically, this sort of material we're going to be looking at today sits right in my skill set. I've had a fair bit of experience with enterprise agreements and much of the other changes related to in the Fair Work Act, and keen to just let people know what those changes are. Biggest changes probably since the introduction of the Fair Work Act, and it really, it's quite a significant bit of legislation.
Yeah, totally. So before we jump into things, just to let everyone know, today's session is being recorded. The recording will be available afterwards on the MyHR website. So we are really open to people asking questions and encourage you to sort of submit questions through the chat or the Q&A throughout the discussion. Just be mindful that because it's being recorded and will be reproduced, let's just keep the details relatively confidential and only information that you're comfortable sharing in a sort of open forum. And like I said, if you do have any questions, feel free to shoot them in the chat or the Q&A channel. Before we do commence, we just want to have an acknowledgement of country, and really in the spirit of reconciliation, we acknowledge the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respects to their elders past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples today. So today's session, I'm just mindful there's a lot of content to get through, which it may feel like we're sort of rushing through some of this content at time, but really today is really much a sort of bit of a summary of what the changes are and a bit of an information session. There's still some information, I suppose, to play out as well. So in terms of today's sessions, we'll be covering some changes to family and domestic violence leave. Now, we ran a webinar on this topic previously, Robert and myself, and we've got a fair bit of interest out of that. That was a few months ago. We were going to do a follow-up webinar, but we thought we'd just sort of do a bit of a refresher in this webinar because some of those changes are coming into effect from 1st of February 2023. So we thought it would be timely to link it in with these broader changes as well. We'll touch on the extension or changes to paid parental leave, which will be coming into effect. Then we will walk through the Fair Work legislation amendment, otherwise known as Secure Jobs Better Pay Bill. There's a fair bit of content there, and this one has sort of definitely attracted a lot of media attention, and there are some decent implications for employers that we would like to run through. And then the final one is the Respect at Work legislation, which, some of these recommendations have been floating around for a little while, and the government has come through and implemented the full suite of recommendations from that report. So there's a bit of background. Robert, I don't know if you want to take us through some of these points here.
Well, I suppose the Fair Work amendment for paid family and domestic violence leave, that was introduced a while back, and it obviously doesn't take effect until next year. Pretty uncontentious sort of bill. very straightforward, and pass through our parliamentary process without too much problems. As with the anti-discrimination and human rights legislation amendment respective work bill, which all comes off that report, the respective work report that was released. Only some, I think, small 7 amendments made there. And then finally, the big change is the Secure Jobs and Better Pay Amendments Bill, which are pretty contentious, lots of amendments, and I suppose as this law rolls out, there'll be a lot to learn about it as parts of it are tested in cases and test cases and things like that.
Yeah, definitely. It seems to have attracted a lot of attention across the board, and so we'll see how it all plays out now. It's been passed. All right, so we've covered some background on to family and domestic violence leave. So as I said, we've previously run and sent out some information on family and domestic violence leave changes. As a sort of broad summary, there is a new paid family and domestic violence leave entitlement of 10 days per annum. So that is on top of the current entitlement, which is 5 days unpaid. So the entitlement is available in full on the employee's anniversary date, rather than accruing across the year. So as an example, the employee will have a full complement of 10 days on their anniversary date that may go towards family and domestic violence leave issues that they may be experiencing. The entitlement does apply to full-time, part-time and casual employees. I do know that the government was quite intent on including casuals as part of this legislation or this amendment, particularly given a sort of vulnerable group in society who may be more greatly exposed to family and domestic violence leave than others. In terms of its implementation, we're looking at the 1st of Feb 2023 for businesses, for businesses who engage 15 or more employees, and for small business employers, so that's less than 15 employees, it will be coming into effect from the 1st of August 2023. Now, the entitlement is at the full rate of pay, and so therefore, if an employee is absent on family and domestic violence leave on a particular day for which they would have received a penalty rate, say for working a weekend shift as an example, then the family and domestic violence leave payment is at that rate of pay rather than their base rate, which excludes that penalty rate. So the penalty rate is included within the family and domestic violence leave payment. In terms of employees taking the leave entitlement, it really can be used for a broad range of matters involved in family and domestic violence leave, and really it's to deal with the impact of family and domestic violence. Example, making arrangement for their or a close relative's safety, accessing police or support services, attending court hearings, and things that are impractical to deal with outside of ordinary working hours. There have been some recent developments since the passing of this amendment, and Robert, I believe you'll be taking us through that.
Yeah, well, I think the main one is the definition of penalty rates expressly covers off overtime. The reasons for that is, during overtime hours, you may need to attend to these matters. Now, where overtime is guaranteed, like I know of many operations where there's maybe a 10-hour day guaranteed, that would clearly mean the overtime would get paid. I'm not sure how it would operate in other circumstances, but if there's a regular pattern of overtime associated with work, the expectation is you would pay that. With respect to casuals, the laws made it clear that will apply to irregular casuals. And by that I mean people for a specific task or season. So, you'll have seasonal workers out in regional country Australia working in agricultural concerns, and they might come out at a set time every year and work casual hours over a picking season or something like that. Now, there might be a large gap between their engagement. They may return at a part of the season where there's not too much work going on and work less hours. But the point to be made here is that irrespective of the length of break, the anniversary date for these sorts of casuals will be the first day they commenced working with you. So that's the takeaway there. And of course, from a privacy and confidentiality point of view, there have been some specific regulation inserted about pay slips. The fact that when a pay slip's produced, it doesn't specify that the leave is family and domestic violence leave, and we'll get tags like paid leave, other leave, special leave. Payroll providers will do the job there, but if you're running your own payroll, you'll need to just have something ubiquitous and anonymous and call it paid leave, I suppose, of some description.
Yeah, totally. And Robert, I just quickly, in terms of preparing for that 1 February 2023 date, is there anything you think specifically that small and medium-sized businesses should be doing to prepare?
Well, I think just making sure their payroll system doesn't get them into any sort of grief. And also, there's a real need to consider what sort of policies and controls you put in place. Not like sick leave, it's 10 days of leave, and if you don't control it, it's going to cost you. Now, this leave is provided for a real genuine reason. It ought to be paid for a real genuine reason, but you need to make your inquiries in an empathetic and sympathetic way to make sure the leave's being used and is able to be taken at a time when the employee really needs it. The role of the employer in helping the employee understand that leave is available is really important. So your policies and procedures about that would be useful, which of course we can help our clients with, Julian.
Totally. All right. Awesome. Thank you. All right. Moving along. So paid parental leave. So this one's probably not as urgent as some of the other issues, but it is a change that has come about recently, and so we thought we would just provide a bit of information on this. So Australian workers will will be entitled to six months of paid parental leave under changes recently announced. Currently, the entitlement is to 18 weeks of paid parental leave, and secondary carers are entitled to 2 weeks. Both of these payments are at the national minimum wage. So in terms of the changes leading into that 6 months, basically it will be phased in from July 2024 with 2 additional weeks of leave, and increasing by 2 weeks a year until July 2026, at which point it will achieve that 26-week paid leave. As part of that, some of the changes as well, there is some increased flexibility. So single parents be eligible to take the full 6 months, while 2-parent households be able to decide how they share the leave. Extended paid leave will be able to be taken in blocks between periods of paid work, and there will also be sort of use it or lose it weeks to enable more partners to access paid leave as well. And there's still a sort of bit to be sort of fleshed out, I suppose, over the next couple of years in terms of like an optimal model for splitting the 26 weeks. So it's just one of those things, I suppose, that we just need to monitor over the next couple of years before the full extent of the changes are implemented. Robert, anything else we should be across in relation to this one?
Well, I suppose the impact is $812.60 per week or $21.60 per hour, and that gets indexed at 1 July of each year. So with the recent Fair Work Commission 5% adjustments, that will be sitting at about $850 by the 1st of July next year. Probably just the mix. I mean, I think you're going to find with the sharing the balance of the caring being an issue and a priority, you may find yourself with 13 weeks for the husband, for the father, 13 weeks for the mother, being a bit of a formula going through. So, I mean, just keeping an open mind to how that leave will work. And of course, understanding the fact that the employees may have other leave, other paid leave they might want to draw on to help keep the cash flow going in this extended period, which is otherwise unpaid. So if there's some annual leave accruals there may be some arrangements entered into where all or portions of that are taken during the period as well, Julian.
Yeah, beautiful. Awesome. All right, now onto the big one, I suppose, the secure jobs better pay bill. So there's, I suppose part of the criticism of the bill was just the breadth of it in terms of the number of changes. But I suppose that's why it sort of there were a few amendments made throughout the process of passing the bill. But if we sort of run through it as it has been passed, I mean, I think fundamentally, I think the government sees it as implementing their election promises, particularly the extent of getting wages going and also addressing sort of gender equity issues in the workplace. So certainly they have included as primary objectives of the Fair Work Act, job security and gender equity, and also, of course, making it easier for employees to negotiate wage increases, particularly at that sort of collective bargaining or enterprise bargaining level, and sort of all the other changes sort of tend to flow from those principles or those objectives. So, as an example, flexible working provisions. So they've gone about sort of extending the circumstances for which flexible working may apply. I think importantly as well, from the government's view, I think they've seen it as too easy for employers to just decline flexible working requests, and so they've sort of made a few more hurdles for employers to pass through in order to consider flexible working requests, and also the consideration of a dispute mechanism, a dispute resolution mechanism through the Fair Work Commission. What are your thoughts on that, Robert?
Well, I think you're right. It's if you've got as a business, if you've got a real genuine reason why you can't offer the flexible employment, you're fine, right? It's where it's a bit chalky and line ball, but the difficulty is, I suppose, is once an employer has a right to challenge your decision, there's then a cost and a concern about, well, how do I then manage that point of disagreement? And it's now going to be formally reviewed by the Fair Work Commission, and pretty much like an unfair dismissal sort of a situation. If there's no ability to conciliate or resolve the matter, there will then be some arbitration. And in the process of doing that, if the employee's been found to be in breach of the Fair Work Act, there's also the prospect that they could be fined, and those fines have been increased to a maximum of $66,600. So we've got the devil's number there for us to worry about as well. So so that is pretty much a consistent maximum penalty for a lot of the breaches related throughout the Fair Work Act, Julian.
So I think, to sort of round it out, I think in terms of those procedural steps that employers need to undertake with the change, so I guess employers need to so currently it's effectively an eligible employee makes a request, the employer needs to respond to the employee within 21 days in writing, and they can decline a request based on reasonable business grounds, which is sort of pretty can be a little bit generic, I suppose. With the change, employers must have discussed the request with the employee and generally tried to reach an agreement to accommodate the employee's circumstances. The employer and the employee have not, despite the employer's genuine efforts, reached such an agreement. The employer must have had regard to the consequences of the refusal for the employee, and the employer must have reasonable business grounds to refuse such a request. So there's certainly much more of a procedural step and even a sort of documentary evidence requirement that an employer would need to have in place in order to in order to decline a flexible working request, hence sort of creating that greater incentive for employers to accept requests.
Well, it could even be putting a counter proposal, It might not be accepting, but you're right, the pressure's on to actually twist and contort and think about the situation in a much more accommodating way. But yeah, by and large, it's a process, and the pressure's on the employer to think about it.
Yeah. Changes to fixed term contracts. So limiting fixed term contracts for the same role to 2 consecutive contracts or a maximum duration of 2 years. That is subject to exemptions, which I think you'll talk us through. Or we've actually got the exemptions on the screen there. So that it includes where it's allowed under a modern award or an extended leave replacement, and sort of emergency or crisis appointment, and there's a few other instances that are listed there on screen. There is a bit of a lead time for this one, so it's 12 months before it's operational. So there's a fair bit of time to prepare for that. But sort of just thinking off the top of our heads, Robert, anything that we'd want to sort of, do to prepare for that, down the track?
Well, I think just knowing where your fixed term employees or your term employment employees are, and just I suppose if the practical consideration is a bit theoretical. I mean, if they're not a fixed term employee, their start date's their first day of employment, and they're an employee with however many months or years service in the event they lose their termination of employment. So it's only significant for a defence in unfair dismissal. You used to be able to use that as a defence in unfair dismissal. I suppose that'll be a bit more limited, defence when unfair dismissal claims are lodged.
Totally. Moving along, a big one, I think, for a lot of employers is the prohibition of pay secrecy clauses. So it will become a workplace right to disclose or to not disclose pay information. And so existing secrecy clauses will be null and void, and it will be unlawful to enforce or include secrecy clauses with a maximum fine of $66,600 there as well.
Yep.
So again, I think that the rationale here is, pay secrecy clauses, reduce transparency, have the potential of contributing to the sort of gender pay gap, and that sort of thing as well. So I think, Robert, it'd be good for businesses to start reviewing their existing contract templates to the extent that confidentiality terms or pay terms may restrict employees providing such information.
Yeah, of course, and we'll be doing that, and obviously reviewing it as there's a little more case law on that specific stuff. Yeah.
I think it's important to point out it's not just pay, it's also other terms and conditions that are reasonably necessary to determine remuneration, so things like hours of work and that sort of thing as well.
Yeah, exactly.
So yeah, Robert, talk us through the matters referred to courts by the Fair Work Commission.
Well, again, it's just it's a bit of pressure being applied by the law. Now, for some reason, you get a matter. These are generally matters through inspectors of the Fair Work Ombudsman who find there are technical breaches of the Fair Work Act. They may have a a breach may result in a court action being taken, and like any other organisation, the Fair Work Ombudsman doesn't want to spend money on lawyers and courts. It wants to encourage agreed and conciliated outcomes. So with the penalty now being 100,000 instead of 20,000, it sort of makes the employer think that maybe, okay, well, if that's the risk, perhaps resolving this matter with the Fair Work Ombudsman so it does not go to court is worthwhile, because there's a sizable cost there if you get it wrong.
Yeah, totally. All right, cool. We've also got sort of advertising jobs at rates below minimum rates of pay will be unlawful. And the Fair Work Commission will have equal pay powers to make orders around equal pay for women, doing comparable work to men, and eliminating gender-based evaluation of work as well. So I think that goes to some of those objectives and the view that traditionally some professions which have been traditionally more female-oriented have been sort of valued as lesser than some more sort of male-oriented professions and industries. So it's going to address that, effectively. All right, so changes to enterprise bargaining. So Robert, I believe you're going to be talking us through some of these changes.
With the time we've got left, I'm going to skate over it and focus on a couple of things. So the first thing is the emphasis of this legislation is to make it easier for unions to negotiate wage increases for employees. And when I mean easier, I mean instead of doing 50 enterprise agreements with one national employer, they can do 1, 2, or 3, depending on the sorts of workers they're doing. So that's the thrust of it. So this term multi-employer bargaining touches on the fact that single large employers have used enterprise bargaining to negotiate site by site. Well, that's going to be less of a proposition. So it's going to make it a little easier to get these negotiations finalised. And when the negotiations are finalised, it hits a bigger target market. So that's number one. Number two, just some administrative stuff is going to be a lot easier. An ordinate amount of time is spent in the Commission dealing with expired in these zombie enterprise agreements. So a zombie enterprise agreement is an agreement that was made before the Fair Work Act, or could include agreements that were made before the Fair Work Act 2009 were introduced. So basically, in 12 months' time, they're gone. Or they can be terminated by agreement between the unions and employees. And if a zombie agreement is going to end, and there's some sense that there's going to be people covered by it, well, you've got to give 6 months' notice.
And the issue with those zombie agreements, right, is that they were negotiated over 10 years ago, provided that the minimum rate of pay or the ordinary rate of pay keeps up with the applicable award, all the other terms and conditions, and terms and conditions consistent with the NES, all other terms and conditions could be lesser than the applicable award.
Well, they've got the same status as an enterprise agreement, which means they override the effect of an award. They trump an award. So I suppose that there's a bit of an issue there. And then, of course, in addition to that, you've just got expired enterprise agreements. So, what do you do when they're expired? Well, the processes associated with that are going to be a lot more simpler. And in some instances, if an enterprise agreement is going to cause some true financial hardship and redundancies, there could be grounds to terminate an enterprise agreement there. In other instances, you could have circumstances where, we're happy to terminate the enterprise agreement, but let's have up to a 4-year transition to move off. Maybe someone who's in a business in, say, the airline industry, working in the road transport industry. Well, the terms and conditions are a lot higher in the airline industry. Let's transition it down to some sort of point where it's consistent with what's going on in the industry they're going to. So you can imagine stuff like that. And of course, the other big focus was the use of application to terminate enterprise agreements as a negotiating tactic in an enterprise agreement, well, that's going to be pretty much frowned on, and there won't be much ability to do that, well, any ability really. It'll be viewed as an unfair bargaining tactic. So termination of enterprise agreements under those circumstances, the regulation is going to stop employers or limit employers' ability to do that.
So I'm just mindful of the time. I see the other one we've got there is the changes to the boots, the better off overall test.
Yeah, so that's all a part of the process of, instead of having a line-by-line assessment of conditions, to see whether the test is passed, it's going to be global. So basically, what happens in the bottom right-hand corner? If the enterprise agreement, bottom right-hand corner, delivers a result better than the award would, bang, you pretty much got...
Because some of the issues, I think, commissioners were considering like hypothetical arrangements that weren't actually in place in the workplace.
Well, correct, but there is scope to revisit your enterprise agreement if that comes under these provisions as well. So it's the here and now, I suppose, that needs to be considered.
In terms of those multi-employer bargaining streams, got a bit of a summary there.
Yeah, well, it's there's 3 streams, all right, and basically the one that's causing all the concern is the single interest bargaining stream, which is really going to be an issue for multinational employers with multiple sites and multiple agreements. And so they're having 50 negotiations out there and shedding the risk of a massive industrial dispute across 50 locations. There's going to be a whole big event they're going to need to deal with. So I suppose that's going to be the material impact of that. But I mean, if you've got less than 20 employees, and by that I mean 20 employees, including casuals, but not irregular casuals, you won't get caught up with that stream. And even if you've got up to 50 employees, you're only going to get caught up with that stream if you pass a threshold and some other tests are met related to commonality, consistency, commonness of businesses to whatever the bargaining is focused on, which industry it's focused on. And the other saviour is your employees. If they do not want to get involved in a single interest in bargaining and they vote accordingly or show no interest, well, that's helpful for employers with less than 50 employees. And the good thing to note is the onus to substantiate getting caught up in this single interest bargaining stream is on the union or the applicant. So if a union wants a business involved, the onus is on them to substantiate the case, which is helpful for those smaller businesses as well. So by and large, that single interest bargaining stream, which is the one that's causing all the controversy, that won't apply in the main to businesses with less than 50 employees, which basically means for a lot of the businesses we're looking at, they're going to potentially be looking at supported bargaining, or they might want to go into a cooperative work bargaining stream where, they want to negotiate an enterprise agreement for some reason. But again, that's probably going to be really unlikely, Julian. So it's that supported bargaining stream which is going to be causing some issues. And fundamentally, Julian, if you've got employees just paying the award wage and there is something similar and common about those businesses, well, they could conceivably caught up in a regional or industry-wide negotiation, but there needs to be some sort of common interest between those businesses to validate their involvement.
And specifically with the supported bargaining streams, my understanding is that's sort of targeted towards some lower wage groups. So those groups who are sort of primarily paid the award rate, is that right? Well, particular industries?
Yeah. Well, particular industries related to, health and aged care and childcare. They've been the targeted businesses. But prior to this stream was only limited, very limited use to employees who could be identified as having 2/3 of the median adult wage. Now, as I said, that definition's gone, and basically I think if you're on the ward and you don't have an enterprise agreement and you're paying award rates and your terms and conditions of employment are common across a bunch of other employers, you're in a common geography or the nature of your business is common, well, you're going to get caught up with this. I mean, government departments, example, education, health departments where they've got funded by government, they'd be included as well. But a consideration in all this is going to be the ability of the businesses and the unions involved in this and the employees involved with this are having a level of expertise. So there's no point having 100 businesses involved, 50 businesses involved in an enterprise bargaining negotiation if there's no capability or resource amongst the employers and all the employees to actually deal with this. So there's going to be some consideration of that as well. And obviously membership of a union will help employees, and employers having an IRHR resource backing them up is going to be pretty critical as well.
Yep, cool. All right, mate. So just to round out the Secure Jobs Better Pay bill, there was just some elements around sexual harassment and discrimination. So the definition of anti-discrimination is extended to include a few additional things like breastfeeding, gender identity, and intersex status. So in addition to that, sexual harassment connected with work will be expressly identified as unlawful. An employer will be liable for the employee's conduct, and policies and procedures to manage will become essential in our view, and employees will have a right to lodge a sexual harassment dispute with the Fair Work Commission. And so the view is that will sort of look similar to current general protections matters managed by the Fair Work Commission.
Or the bullying and harassment ones as well.
Yeah. And so a lot of this is sort of connects well with the sort of Respect at Work report and recommendations as well. So the government has passed legislation which implements the remaining recommendations from the 2020 report. So basically, there's a report performed by conducted by Kate Jenkins in 2020. She provided a number of recommendations, I believe 55 in total, to the government. The government of the day implemented most of those recommendations. So an example is just making it clear in the Fair Work Act that sexual harassment was a valid reason for dismissal. So in terms of the remaining recommendations, I think the main one really is introducing a positive duty on employers to take reasonable and proportionate measures to eliminate sex discrimination, sexual harassment, and victimization as far as possible. Would you say, Robert, that's probably the main element there?
Well, it's clearly unlawful and not right to be terminating people because of for reasons that relate to sexual discrimination, sexual harassment, and discrimination, etc. So it's right. The law is clear and consistent with the other discrimination instruments that cover this. So it's just a tidy up, I suppose, of ensuring that the system can deal with these issues, and more particularly, again, the onus is then on the employers to understand there are penalties and problems in not addressing this. So that's the real thrust of it there, Julian.
And I suppose the principle going to that positive duty, it's similar to like work health safety more broadly, right? In terms of implementing as far as reasonably practicable, or reducing the risk of an incident occurring, and putting measures in place as far as reasonably practicable to prevent such an incident from occurring.
Well,
right?
it really, really clearly makes these matters very much like work health and safety matters.
Yep.
And they are. I mean, by and large, they are already, but this is just absolutely making it
clear
that there is, and then there's specific processes and remedies you can go to if there's a failure to meet those obligations. Yeah.
And it also goes to things like hostile workplace environments on the ground of sex. So I think there's specific reference made to sort of workplaces that display obscene or pornographic material, sort of general sexual banter. It's really sort of capturing sort of broader workplace culture rather than
pinpoint. You're quite right. It's what's the cause of the specific events, and if the cause of the specific events is a laxness on the employer's part to make it clear that this is wrong, well, it sheets home back to the employer again. Yeah.
And look, a lot of businesses that we meet with, they might sort of have a few policies and procedures floating around and that sort of thing, but probably nothing that would be sufficient, I think, to deal with these recommendations. What would you want to see in a policy, or broader than a policy? Because I guess a policy is, it's sort of, it's relatively easy to put some words on paper. What are the sort of broader initiatives that you think workplaces would want to demonstrate this positive duty?
Yeah, well, I think pretty much like you would identify a risk at work. So there's a policy and there's a work procedure, as to how deal with certain things. So the legislation itself is going to create specific requirements that employers must observe. So, your policy is going to have to tick that up a bit like, Section 387 of the Fair Work Act with respect to unfair dismissal. You need to look at the specific sections in that legislation to ensure your process at work complies with the law. Well, there's going to be some detail here, and your policy is going to need to tick off each of those new requirements going forward.
Yeah, totally. And I think, sort of as part of that sort of broader sort of induction material training and that sort of thing, like ongoing regular training, I think, as a sort of refresher and reminders. And I believe that a Respect at Work portal has been, a website is up and running now, which has some pretty good materials for employers there as well.
And training, training opportunities there for your team leaders and people leaders. Yeah,
totally. All right, so that covers the main content for today's session. So thank you everyone for attending, and hopefully you got something out of the session today. Just having a look now, it doesn't seem like we've had any questions up until this point. We know it has been there has been a fair amount of info that's been put out by us today. So we do thank you for sticking with us. But if there is anything you want to clarify or you do have any questions, now is the time to submit it in the Q&A or the chat, and we would be happy to address the question. And as I'm talking, I can't see any questions coming through. So I think we could probably wrap up the session.
If you do have questions, please send them through the MyHR system, and either Julian and I will be able to help you out.
Yeah, totally. All right. Awesome. Thank you, everyone, for attending today's session. Just a reminder, this recording will be available on our website, so you can come back and watch it at any time. We have had a question come through from for fixed term contracts, one of the exceptions is government funding. Would this cover funding that is renewed regularly?
Well, government funding, yes, that is certainly one of the exceptions that could be used. It might be funding through another source as well. But absolutely, that is one of the exceptions. Yeah.
Yeah.
So if you've got a fixed project that's dependent on government funding, and you've got an employee connected to that activity, and that activity is based on the funding. Like the funding might be extended and reviewed annually or biannually or over some sort of periodic time frame. And in those instances, yeah, I mean, once your funding's gone, well, I suppose you don't have a job. So that's the end of it. So that clearly is one of the exemptions, yeah.
Yeah. And the intention is more to go towards situations where employers place somebody on a fixed term contract just to provide greater flexibility for themselves, even though there's not really any sort of basis to it, right?
Well, if you're going to employ someone for 2 years, I suppose the only advantage you've got again is that defence against unfair dismissal. So, other than that, they're accruing leave. They're clearly not going to be eligible to redundancy because of the nature of their employment. But you're still going to have to terminate the person and provide them with the appropriate notice in accordance with the contract. So there are things you've got to do correctly, even if it is tied to funding. So, but funding certainly is an issue, and academics. Oh my heavens! Yeah, there's been research grants. Situations like that. I've got to imagine that exemption being used, and I suppose from those organisations' point of view, so long as the funding's there, they've got a job. But once the funding's gone, well, there's no cash to pay. So that's the end of it.
Yeah. All right, I think that's the only question. So, all right, thank you everyone for your time. Yeah, like I said, the recording will be available on site on our website. Feel free to reach out to us if you've got any questions as a result of this webinar or for any other sort of HR related matters. Otherwise, have a great rest of the day. Thank you.
Thanks for your time, everyone. Cheers.
Bye.